to hearsay. The officer saying, I can't believe Jordan Ryder would do this. Now, we understand that that's a common way to say that you can believe something. We're not offering it to prove that Jordan Ryder actually did this, and thus it falls under that exception.
Your Honor, may I respond?
Yes.
8033 doesn't say the word belief. This is an out-of-court statement being used for the truth of the matter asserted.
May I respond to that, Your Honor?
Yes.
Now, if you look at the language of the law under 8033, it actually does say the word belief. It says that you can't offer statements of belief if you're trying to prove the contents of that statement believed. However, we're not trying to prove the contents of the statement believed, that is, Miss Ryder actually did this. And thus, we're allowed to enter this statement under 8033.
May I respond?
Hold on. Are you trying to enter it for the truth of the matter or not the truth of the matter?
We're trying to enter it not for the truth, and not that Miss Ryder actually did this, just to show belief of the officer.
Okay. I'm going to sustain the objection.
Motion to strike, Your Honor.
No answer had been given. It's just a question.
Yes, Your Honor.
Mr. Dews, when the police found Parker's body, you heard an officer say Miss Ryder never should have gotten out.
Objection, Your Honor, to hearsay.
May I respond?
Yes.
We're not offering this for the truth that Miss Ryder never should have gotten out of prison. We're just offering it to show the understanding or the beliefs of the police officers. This goes to bias, and thus it's admissible.
May I respond?
Yes.
Your Honor, if there's bias in this statement, then that's the truth value being asserted.
Well, the fact that a statement is made by a police officer, that's different than the 8033 objection that was made before. So, to the extent that there's bias made by a police officer investigating this, I'm going to allow it.
Yes, sir.
Mr. Dews, you heard that officer say Miss Ryder never should have gotten out of prison right when they found Miss Page's body.
Well, I wasn't there exactly when they found Parker's body, but they were talking about that when we were there.
After they found Miss Page's body, that's when you heard that statement, right?
Right, yes.
And Mr. Dews, you heard this statement from the police officer before you wrote your affidavit.
Yes, I believe so, yes.
You heard this statement from the police officer before you decided to come to court to testify.
Yes.
So I want to talk about what you're telling us in court today after you heard what the police had to say.
Sure.
You told us that when you saw Parker and her mother on the Lacrone Loop, they were at the overlook right here.
Yes, right, the intersection of the two trails.
Mr. Dews, from the trailhead to the overlook, that's about 3 miles, right?
Yes, about.
There's quite a bit of elevation there.
Yes.
But sir, you were only 20 minutes into your hike when you saw the two.
I would say I was probably closer to 30 minutes.
So you made it 3 miles uphill in 30 minutes?
Yes, I tried to make the hike, difficult for myself,
Okay, Mr. Dews. You also told us that you saw Miss Ryder take the hiking stick out of her daughter's hands.
Yes, I did see that.
But she only did that after her daughter was hitting her in the legs with that hiking stick, right?
I wouldn't say that she was hitting her. I would say she was tapping her with the hiking stick.
She was tapping her in the legs, and only then did Miss Ryder take away that hiking stick.
Right, yeah.
You also told us that you heard a scream coming from the Lacrone Loop.
Yes, I did. I heard the scream coming from that point right there.
Sir, you weren't at that point when you heard the scream, were you?
No, I was going up the Corkins Rock Overlook route right there.
Right, you walked away from the spot you'd seen Parker and her mother.
Yes, I did.
So you couldn't see the two.
No, I couldn't because there was the tree line there.
So you can't tell us for sure that that scream you heard was Parker because you couldn't see her.
Well, I know that when she was yelling at Jordan, I hate you, I know that was definitely Parker.
Sir, I'm not asking about what she was yelling at her mom. Rather, that one scream you heard, you can't tell us that it was Parker because you couldn't see her, right?
Yes, I heard the scream. It was a terrifying scream. I can't tell you exactly who it was, but like you said, I couldn't see them.
Mr. Dews, When you saw Parker with her mother on the trail and when you heard that scream, at neither time were you worried, were you?
Well, I just assumed that it would work out.
Mr. Dews, when you saw Parker and her mom both times on that trail, you didn't tell anyone about what was going on.
Tell anyone? Who would I tell?
I don't know, Mr. Dews, but you didn't go to someone to report what Miss Ryder had done.
No, I didn't. After the hike, it was quite late, so I went back to my cabin.
Right, Mr. Dews? You didn't think there was a problem, so you just walked away.
Well, I just finished the hike. I had no idea that Parker was dead.
Mr. Dews, you don't know when Parker died, do you?
I can tell you exactly, but ma'am, I do know that she was dead the next morning.
But you can't tell us exactly what time she died, so you don't know if when you were on that hike, Parker was dead.
No, ma'am, I don't know that.
And after you heard that scream, you didn't call the police.
No, I didn't.
You didn't tell the owner of the campground, sir, because you weren't worried, right?
Yes, like I said, I mean, I was quite scared when I saw what I saw, but I just figured that it would resolve it, you know?
So that's a yes. You didn't tell anyone because you thought it was okay.
I thought it could be, yes.
Thank you, Mr. Dews. Your Honor, I have no further questions.
All right, does that prompt any redirect?
No redirect, Your Honor.
All right, thank you, Mr. Dews.
Thank you.
All right, third witness from the state.
Yes, Your Honor, the state calls Dr. Rebecca Quincy to the stand.
All right.
Permission to proceed?
Are the scoring, you good? All right, you may proceed.
Good afternoon.
Good afternoon, Mr. Godet.
Could you please introduce yourself to the members of the jury?
I'm Dr. Rebecca Quincy.
Dr. Quincy, what do you do for a living?
I'm the Chief Medical Examiner for the Breckinridge County Coroner's Office.
How'd you get into that line of work?
Well, my mum wanted me to be a surgeon, and my dad wanted me to be a detective. I thought maybe this would satisfy the both of them.
Could you tell the jury a little bit about your educational background?
Sure. After coming to the States, I got my biomedical science degree from the Ohio State University, and my MD from the University of Virginia.
Doctor, could you tell us how you're involved in today's case?
My office is the main point of contact with the police when an autopsy is required. Last July, I was asked to perform the autopsy of Parker Page.
What materials did you review in your examination?
I looked at the subject's medical records, her toxicology report, and of course, her body. All of which were more than enough to work with.
Well, what method did you use?
I used the Latour method in my examination.
What's the Latour method?
The Latour method is a two-step process for conducting an autopsy, which requires both an internal and an external examination.
Doctor, what can the Latour method tell you?
It tells me how a person died. So if their death was accidental, environmental, natural, or caused by another person.
Now, you said the Latour method has two steps. I want to break those down for the jury. Could you explain how the first one works?
The first step is the external analysis of the subject's visible features, so any wounds or abrasions that they may have sustained, which tells me how they died. And this is done at the site of the subject's death.
How about the second step, Doctor?
That's the internal examination of the subject's inner organs and bones. We start from the abdomen and work outwards in a Y-shaped incision. This is also the point at which I calculate time of the subject's death.
How do you do that?
Well, I measure the subject's inner body temperature, and then I use that figure in a standard formula to calculate time of death.
And could you explain for the jury how that formula works?
It's pretty intuitive. You use heat loss from the body to work backwards and determine how long it's been since the person died.
Doctor, is the Latour method standard in your field?
Of course. It's the gold standard for conducting an autopsy across the board.
And did you reliably apply the Latoul method to the facts of today's case?
Yes, I conducted Parker's autopsy according to the Latoul method.
Now, I want to talk about the first part of your conclusions. Were you able to determine when Parker Page died?
I found that Parker died between 4 and 6 p.m. on July 14th, 2018.
Doctor, how sure are you that she died between 4 and 6 p.m.?
I'm very certain. I was able to corroborate my findings from the formula by looking at the subject's liver mortis and rigor mortis, which are just scientific terms for the discoloration of the skin and the stiffening of the joints. And those were able to confirm that Parker died between 4 and 6.
So, Doctor, if she fell off that cliff at 4:40 and died, would that be consistent with what you found?
Yes, that would be well within that range.
Now, I want to move on and talk about the second part of your conclusions. Were you able to determine how Parker Page could have died?
Yes. I found that the cause of death was blunt force trauma to the head, which occurred as a result of falling from a 40-foot elevation. However, I also found evidence of an injury unrelated to that fall.
Unrelated to the fall. What do you mean by that?
I found evidence of an injury on Parker's left clavicle, which was inconsistent with her other injuries. I actually have a model to help explain that inconsistency.
Your Honor, may Dr. Quincy step down and make use of this model?
Has the defense seen the model? And...
Yes, Your Honor, we have seen the model. We actually have an objection to this.
All right, so before you show it to the jury and have her get off the stand, so you should stand up there while you argue, what is your objection to this model?
Substantially more prejudicial than probative. May I be heard?
Yes.
Now, as we've heard from both the state and the defense today, Parker Page had a disease known as osteogenesis imperfecta.
Okay.
That changed the way that her bones were formed, and it changed the way that that her skeleton was formed. Now, opposing counsel is bringing in a standard human skeleton, one that's around 5 feet tall, one that's around an adult's body. Parker Page was only 12 years old. She was only 4'8". She had this disease. By showing Parker Page's injuries on this skeleton that didn't match her body, that would mislead the jury.
Okay. What is your response?
Yes, Your Honor. The only reason we'll be using this skeleton is simply to show the locations of the injuries on Parker's body. We're not saying that it is in fact her skeleton or anything like that. And furthermore, for evidence to be excluded under Rule 403, the prejudicial or the misleading effect must substantially outweigh the probative value. We believe there's been very minimal prejudicial effect, as we're only talking about the locations, nothing about the bone formation or anything like that.
Okay, so to that extent, I'm going to let them do the demonstration. To the extent it's solely for a model of here's where this is located, that's fine. If you want to renew the objection based on testimony, and if it goes too far, feel free to renew.
Yes, Your Honor.
I may Dr. Quincy step down.
She may.
All right, so what are we looking at here, Dr. Quincy?
This is a model human skeleton which I used to map out injuries. One of my interns at the coroner's office named her Nell.
So could you describe Parker's injuries for the members of the jury?
Of course. Parker sustained 10 fractures and 3 abrasions. Now, the first major injury to note is the trauma to the right ocular region here. Thank you. Now, this is where I found cerebral contusions, subarachnoid and subdural hemorrhaging, as well as significant inflammation of the frontal lobe. Moving on to the rest of the right side of the body, I found trauma on Parker's torso here, perfect, which included 6 broken ribs, and the tibiofemoral region, further down. Thank you.
Objection, Your Honor. Sorry, just point of order. May Ms. Ryder excuse herself to use the restroom? So sorry.
That's fine.
Apologies.
Like I was saying, the kneecap, as well as the bimalleolar region, the ankle. Thank you. Now, these injuries are all consistent with the impact of falling and landing on her right side. But what struck me as unusual was the appearance and positioning of the trauma on Parker's left clavicle here. Yes, perfect.
Your Honor, let the record reflect I've placed pink stickers on the right side of the head, rib cage, kneecap, and ankle, and a green sticker on the left clavicle.
record will reflect that.
Dr. Quincy, why did this left clavicle injury stand out to you?
So, first of all, it was on the opposite side as all of the other injuries, which indicates to me that it was caused by a different source of trauma. Not only that, but the ecchymosis, or the bruising, was much lighter in colour on the left clavicle compared to any of the other injuries, which tells me that it happened before she died. So in other words, Parker sustained the left clavicle injury in a separate incident before she fell and sustained these injuries.
You said she sustained this injury before she died. Do you have any idea how that could have happened?
Well, the bruising measured 2.25 centimeters exactly and was a perfect semicircle shape. It was also completely isolated. I mean, there weren't even any scratches on the rest of the left-hand side. And so for those reasons, I was able to rule out environmental and natural causes of death.
Thank you, doctor. You can retake your seat. Now, you said you were able to rule out environmental and natural causes of death. Do you have any idea what could have caused that injury?
I did